Mesdames et messieurs, chers collègues, j'ouvre.
Ladies and gentlemen, I am now I call the meeting to order. Welcome to meeting number 52 of the House of Commons Standing Committee on Industry and Technology. Pursuant to Standing Order 1082 and the motion adopted by the committee on Wednesday, January 26, 2022, the committee is meeting to study the proposed acquisition by Shaw by Rogers. Today's meeting is taking place in a hybrid format pursuant to the House Order of Thursday, June 23rd, 2022. So those who are online can use the option to raise their hands. For the first hour, we have from the Competition Bureau, Jean Pratt, Senior Deputy Commissioner, Mergers and Monopolistic Practices Branch, and Anthony Durocher, Deputy Commissioner, Competition Promotion Branch. From the Department of Industry, Éric Dagenet, Senior Assistant Deputy Minister, Spectrum and Telecommunications Sector, and Marc Chan, Senior Assistant Deputy Minister, Strategy and Innovation Policy Sector, Science and Economic Development Canada. Thank you for being among us. So, without further ado, Competition Bureau for the next 5 minutes. Good morning, Mr. Chair and members of the committee. My name is Jean Pratt, Senior Deputy Commissioner, Mergers and Monopolistic Practices Branch. I'm joined today by my colleague, Anthony Durocher, Deputy Commissioner, Competition Promotion Branch. The role and mandate of the Commissioner of Competition or of the Commissioner of Competition are clear. He administers and enforces the Competition Act to the benefit of all Canadians. Protecting competition is vital to the interests of Canadian consumers and businesses and to overall economic performance. The Competition Act's merger provisions are the frontline defense against the accumulation of market power.
The Bureau conducted a comprehensive review of the evidence during our investigation. This included over 100 meetings with stakeholders, the collection and review of over 3 million records, as well as 7,800 submissions from the public. On May 9th, 2022, the Commissioner filed an application to the Competition Tribunal under Section 92 of the Competition Act, seeking to block the proposed merger. This action was taken because our position was that the transaction would likely harm millions of Canadians in Alberta and British Columbia through higher prices, lower quality services, and lost innovation. At the tribunal, we argued that Shaw is a growing competitive force in Canada. When the proposed acquisition was announced, Shaw was poised to continue as an unmatched disruptive force. The Competition Tribunal agreed with the Commissioner that Shaw was about to launch 5G wireless services and expand their wireless services into new areas, reaching more Canadians. These plans were shelved with the announcement of the proposed Rogers-Shaw merger in March 2021. On August 12, 2022, Rogers-Shaw, Videotron, and Quebecor announced that they had entered into an agreement for the sale of Freedom Mobile. We took the position that the sale of Freedom to Videotron did not sufficiently address the anti-competitive effects of the merger. Videotron itself was not our concern. Rather, even with the divestiture, Videotron would not have the assets needed to compete as effectively as Shaw. Due to several long-term agreements, rather than having ownership and control over critical assets, Videotron would be reliant on their competitor, Rogers. This would reduce Videotron's incentive and ability to compete and create avenues for Rogers to undermine New Freedom's competitiveness. On December 29, 2022, the Competition Tribunal dismissed our application. Yesterday, the Federal Court of Appeal dismissed our appeal. We stand by the findings of our investigation and our decision to challenge the merger. We brought a strong, responsible case to the tribunal after conducting an exhaustive investigation. We continue to disagree with the tribunal's findings and are very disappointed. That said, we accept the decision of the Federal Court of Appeal yesterday, and we will not be seeking leave to appeal to the Supreme Court of Canada. I look forward to your questions. Thank you.
Merci beaucoup. Je céderai maintenant la parole.
Thank you very much. Now, Mr. Dagenet or Mr. Chan?
I lead the sector responsible for the Spectrum Management Program, which ISED administers on behalf of the Minister of Innovation, Science and Industry. And my colleague is responsible for ISED's strategic policy function, which includes stewarding the minister's role in both telecom and competition policy. And you've just heard from our colleagues from the Competition Bureau. I understand the strong interest in this committee in the transfer of licenses between Shaw and Rogers and then between Shaw and Videotron. While I can speak about the spectrum transfer process, I cannot speak to the ongoing review of the application to transfer Shaw's spectrum licenses to Videotron. This matter is currently before the minister. As I outlined in my appearance in April 2021, access to spectrum is vital to the provision of wireless services, and the power to issue spectrum licenses, including reviewing and approving their transfer, is at the center of the minister's review and his role of this proposed transaction. The minister regulates spectrum according to the powers granted in the Radiocom Act with due regards to the Telecommunications Act. And in doing so, he may take into account all matters he considers relevant to ensure the orderly development and efficient operations of wireless communications. Now, given the importance of mobile connectivity and the significant investments associated with it, the minister manages spectrum according to an established set of guidelines and policies. Par conséquent, les transferts.
As such, commercial mobile spectrum transfers are guided by the Spectrum License Transfer Framework. This framework supports the government's objective to maximize the economic and social benefits that Canadians derive from the use of spectrum. It also helps ensure the efficiency and competitiveness of the telecommunications industry and the availability and quality of services. In reviewing transfer requests, ISED analyzes, among other factors, the change in spectrum concentration levels that would result from the license transfer, and also the ability of the applicants and other and future competitors to provide services. We may also take into account other factors, including current license holdings of the applicants, overall distribution of license holdings, services to be provided and the technologies available, availability of alternative spectrum, characteristics of the region, because the spectrum is determined by region, including urban-rural status, population levels and density, or other factors that impact spectrum capacity or congestion, and any other factors relevant to the policy objective that may arise from the license transfer. As stated in the framework, the application and supporting materials are treated confidentially. That said, I can confirm that the original Shaw-Rogers transfer application was refused by the minister as it raised, and we have this on our website, it's public. One of the reasons is that it raised substantial concerns about spectrum concentration, among other issues. The issue before the minister now is the transfer application of spectrum licenses from Shaw to Videotron. The initial request was refused, and we are talking about a new request. As Minister Champagne has confirmed yesterday, ISED will announce a decision on the transfer later on. Thank you, and I'm happy to take questions.
Merci beaucoup. Thank you very much. Colleagues, before we start, we'll go for 2 rounds of questions, which will take us a little further than 11:40 as was scheduled, but I will be stricter on time than I usually am, so please govern yourselves accordingly. So we'll start with the Conservatives for 6 minutes, I think, MP Perkins.
Thank you, Mr. Chair, and thank you, witnesses, for being here. I want to begin by stating that I believe that 3 issues are causing our economy to be the least productive of Western countries. Too much government debt, not enough growth with low production of goods the world wants, and a cost of living crisis eating up our paychecks. Our many anti-competitive service industries, with only 2 or 3 national companies per industry, contribute to this cost of living crisis, forcing Canadians to pay too much for what they need. And this is why we are here today. Today, Canadians pay some of the highest cell phone and internet prices in the world, primarily because there is much less competition than 10 years ago. Mr. Dagenet, do you believe that Canadians pay too much for cell phone services? Yes or no?
There is an issue that reports have shown that cell phone prices tend to be higher in Canada than in other jurisdictions.
Thank you, Mr. Dagenet. So this chart here, if you can see it, shows the regular pricing of various packages for cell phone services last week available on the internet for Videotron and Freedom. Videotron's pricing is in gray and is higher than Freedom's prices in gold in most cases. Since Freedom's pricing is already lower than Videotron's, the minister's condition that Freedom match Videotron's pricing will not
Point d'ordre,
reduce
Monsieur le
any
Président. Je veux
pricing.
juste valider. Je sais
Isn't
qu'en
that the
Chambre, on
truth?
peut pas.
I just want to validate something. I think that in the House, we are not allowed to show such a graph. I think I would like to check if we're allowed to do this in a committee. I would like to double check.
Oui, merci, Monsieur le Maire.
Thank you, Mr. Lemire. Unlike the House, we have more permission, so indeed it would be possible to broadcast something on the screens, so I would be more inclined to allow this. Thank you.
So I'll ask the question again. Since Freedom's pricing is already lower than Videotron's, the minister's condition that Videotron match Freedom's prices really doesn't change anything in the pricing mix, does it?
This is part of the transaction that's before the minister that I can't really comment on. I apologize for that.
When Videotron appeared before the Competition Bureau, the tribunal, it made commitments about how it will operate the business in future. And when any company appears before the tribunal, they make commitments about the future. So, Mr. Dagenet or perhaps Ms. Pratt, are any of those commitments made before the tribunal binding on that business?
Well, maybe I can speak to the tribunal's decision. The tribunal's decision did not include an order that would enforce any such commitments.
Mr. Dagenet, during the proposed time of the acquisition of Shaw by Rogers, you have been lobbied extensively by the privileged access the Liberal government has granted to Rogers and Quebecor. Will you share the notes of yours and all officials who attended those more than 60 meetings with this committee?
I don't think I have any notes from those meetings. I'd have to take that back to see how that would, how I'm supposed to share that, if it's through an ATIP or if there's a special mechanism to share with the committee.
Documents and witnesses
Okay,
can
well,
usually table them if they
So I'll
feel
get
free
back to
to.
the
So
chair.
I would
Yeah.
ask that you get back to us. I'm sure officials took notes in the more than 60 meetings. Mr. Dagenet, the CRTC is doing an investigation into Rogers' preferential pricing to Videotron in the case launched by TechSavvy. This case deals with undue preference as a CRTC regulation. Will the minister wait for this ruling before he announces his public decision?
Well, the minister yesterday said he would take a decision in due course. I can't really expand or give you any additional precision beyond what the minister's statement from last night is.
The Minister of Industry, I understand, has unlimited powers to impose conditions through the Radio Telecommunications Act on the issuance or transfer or approval of any spectrum license, and hence the conditions that the minister proposed in October. If concern for high costs for that Canadians pay for cell phones drives overall government policy, can you inform me if the Minister of Industry since 2015 has ever imposed any conditions on Bell, TELUS, and Rogers to specifically reduce prices in any of the access to their towers or infrastructure as part of issuing or renewing licenses?
So the minister, maybe he would like unlimited powers, as you suggest, but the powers aren't unlimited in the Telecommunication Act. They're very well defined. ISED has taken, through the minister, has taken a number of measures to reduce prices. The most, I guess, would be to increase competition and to ensure that there's competition. I mean, at the end of the day, when we look at the Competition Bureau's own findings, when you have, a regional player that's competing against the three incumbents and they have a decent market share, that brings prices down by 35 to 40%. So competition brings prices down. And we've taken measures in spectrum auctions. We've had set-asides or caps. We've put competitive measures, have deployment conditions. All of these things are designed to ensure that people have the spectrum they need to compete.
I understand that that happens, but the question was around conditions. The minister is choosing to impose conditions on this transfer license, but has not imposed in previous transfers, is my understanding. So I understand
MP
the
Perkins.
prices have gone up.
I'm very sorry, but this is all the time you had, 6 minutes. Okay. We'll have to turn now to MP Fillmore for 6 minutes.
Thank you, Chair, and thanks to the witnesses for joining us today. And hello today from Halifax. I apologize for not being able to be with you in person. Mr. Dagenet, thank you for being here today. Now, I understand that you are the ADM responsible for spectrum policy at ISED. So let's just start out with a kind of a basic question, a fundamental question. What is licensed spectrum?
So spectrum refers to the radio frequencies that are used to transmit wireless signals. I mean, it's the air around us. I mean, it sounds a bit magical, but that's what it is. And essentially, whether it's satellites or your smartphone or, your Wi-Fi at home, if it's wireless, it uses spectrum. And at ISED, we try to manage the traffic. There's a lot of data being transmitted over these wireless airwaves. And sometimes the best way to manage that traffic to avoid interference is to have a license, to give a license to someone. So we have a license that gives exclusive use over a specific spectrum band in a specific market. And then that person can use that spectrum band to transmit over a number of years. And that's what we call licensed spectrum. And the telecommunication industry, the wireless industry, makes use of a lot of that licensed spectrum.
Okay, thank you. And so, we're hearing in this discussion about the transfer of licensed spectrum. How does licensed spectrum relate to the discussion before us today with regards to Roger Shaw?
Right. So for the Minister of Industry, Science and Innovation, his role is just that. It is to look at the part of the transaction that relates to the transfer of the spectrum licenses. So Shaw has a number of spectrum licenses that they initially wanted to transfer to Rogers. The minister refused the transfer of those licenses. And again, the explanation and the reasons why have been published. And now we have a revised transaction that's before the minister whereby Shaw wants to transfer its licensed spectrum to Videotron. So that's the four corners of what the Minister of ISI is reviewing at the moment.
Okay, so his decision is around the licensed spectrum transfer, and I just want to be clear for folks that are paying attention that his decision is not around the approval of the merger. That's not his bailiwick. That's correct, right?
That's correct. Competition matters fall to our colleagues at the Competition Bureau and the Commissioner of Competition. I don't know.
Okay, thank you. Yeah, if the Competition Bureau wanted to add anything there, I'd welcome that.
We did bring this case. We conducted an exhaustive investigation. We did find that the proposed merger between Rogers and Shaw was likely to substantially lessen in competition in Alberta and British Columbia. We subsequently looked at the divestiture of the Freedom assets. We evaluated that under our usual procedures and guidelines with respect to evaluating remedies under the Competition Act. And we found, our findings were that the divestiture of assets of Freedom fell short of addressing the breadth and the scope of the substantial lessening of competition that would result from the merger. That's why we brought the case to the tribunal. We lost at the tribunal. We lost at the Federal Court of Appeal. So, our process now is done with respect to this merger.
Okay, thank you for that. If I could come back to Mr. Dagenet and the licensed spectrum question. I mean, we have to assume that there are very specific criteria. In fact, I think you've alluded to them by which you judge your evaluations on spectrum transfer. Well, what exactly is the basis for the decision? What's the criteria that the minister will be looking at?
Right, thank you. So we have a spectrum transfer framework. It's a document that was put out, it was either 2013 or 14, pursuant to public consultations. And it lists what the objectives of the transfer framework are, and it lists the criteria. So essentially, you've got 8 specific factors that may be relevant in ISED's assessment. One is the current license holdings of the applicant and their affiliates in the licensed area, the overall distribution of license holding in the licensed spectrum band and commercial mobile spectrum band in that area, the current and or prospective services to be provided, the technologies available, the availability of alternative spectrum that has similar properties, because not all spectrum has the same properties, the relative utility and substitutability of the licensed spectrum, the degree to which applicants and their affiliates have deployed networks and the capacity of those networks. So do the people to whom the spectrum is being transferred to, do they have the ability to use it and serve Canadians? The characteristics of the region, including urban, rural status, population levels, et cetera, because you don't need as much spectrum if you're not serving as many people. So the density, the population density matters. And then any other factors relevant to the policy objective that may arise from the license transfer or the prospective transfer. So the factors are set out in a regulatory framework that takes its cues from the Radio Communication Act and the Telecommunication Act.
Merci beaucoup, Monsieur Dagenet. Mr. Chair, is there any time left?
Not enough for another question, 15 seconds. So thank you, Mr. Fillmore. We'll leave it at that. Et je tournerai maintenant.
I now pass the mic to Mr. Lemire for 6 minutes. From the get-go, I would like to correct something that was said in the media on January 16th by the Canadian press. They said all of the parties accepted to have this meeting, and it's not true. I was against it because I was uncomfortable with this public audience, namely because of specific factors that came out during the study. And I think that there are interests that are more related to lobbying than public interest. There is the drought competition board review narrative that is problematic. TELUS is using us strategically, of course, with other partners, and I'm very uncomfortable with that. These are things that I have already brought up in the committee, and they are things that I really wanted to bring up again today. So going forward, I wanted to provide a constructive element to today's meeting. This was a transaction that we had already studied in the committee, and we had jointly rejected that first agreement. Yesterday, the tribunal made a decision which supported our decision. So our work is, of course, relevant. In the current context, what was brought up was the wireless aspect of things. So the buyback by Québécois brought up this fourth player into the Canadian market. In this acquisition, Shaw and Rogers had a favorable outcome, and accessibility and affordability were priorities. There have been many discussions over the past few months, and we studied Shaw Rogers, and I think we have a better agreement between Shaw Rogers and Québécois for the consumer. For those who followed this issue very closely and read yesterday's decision, I would like to say the following. When competitors complain against a merger, it means that the merger is likely to encourage competition. TELUS's strategy with Fox is important. Here is my question for Ms. Pratt. On November 14th, all media talked about the fact that the buying of freedom was trying to be blocked. Is this the kind of competition that you are ready to support? I will continue in English because this is too technical.
whenever competitors come to us in investigations, we are skeptical. We look at the evidence, we look at the underlying documents, we look at the incentives and the ability to compete. So, we do have a degree of skepticism when we are dealing with incumbent competitors in the marketplace. What drives our decision making is the totality of the evidence that we look at in our investigation. And in this particular case, we thought that led to a substantial lessening of competition emanating from the Rogers Shaw transaction. As mentioned in my opening statement, our concern was not with Videotron. Our concern is with the assets that Videotron will have to compete, as opposed to what Shaw had to compete prior to. And we, under our remedies bulletin, we just did not think that those assets were sufficient to address the substantial lessening of competition from Shaw's exit.
Why do you insist on keeping the cap on the initial Shaw-Rogers agreement? As what I'm getting the impression of is that your role is one of being a bit of a coach, and it's kind of like you took the puck and gave it to the other team of the Fox collective. I feel like you've gone beyond your role and you played a strategy which was to expand the delays. Why have you ignored the acquisition of Rogers Shaw, of Shaw Freedom Mobile by Videotron in your decisions?
So the way that we look at it in accordance with the framework under the Competition Act, we evaluated the Rogers Shaw transaction. Our investigation determined that that transaction itself was going to substantially lessen competition. We brought an application to the tribunal in May 2022. There was no proposed acquisition by Videotron at the time we launched the application. That divestiture and all the agreements came to light in August, 3 months after we had filed our application. We evaluated it as a remedy. That is how the parties proposed it to us. And so we evaluated it as a remedy to address the anti-competitive effects of the Rogers Shaw transaction. That is what we did. Ultimately, the tribunal disagreed with us. The tribunal thought that we should not be evaluating as a remedy, that it was a new transaction as of August 2022. And so ultimately, the tribunal disagreed with us.
My time is up. Thank you, Mr. Lemire. Mr. Massé for 6 minutes.
And thank you to the witnesses being here. And first of all, I'd like to apologize to Mr. Lemire. It was my Canadian Press comment that I forgot to separate the block from that, and apologize to him. We've had conversations on that. I want to be clear because he is very capable of speaking for himself, as we've seen. Now, going quickly to this matter at hand. Since 1993, Canada basically decided to deregulate our telco sector in many respects, and we've had subsequent prime ministers and ministers of industry do a number of different ventures that's led us here to today. It's a cast of characters that's long and very bipartisan. And my first comment to Mr. Desjardins is to really find from yourself is how do you think this minister is going to get it right? Given the fact that we've had, the situation we are right now, what makes a difference at this moment? Because going back from Mulroney, Chrétien, Martin, Trudeau, Harper, and then a whole series of industry ministers I've met with and worked with over the years, ranging from Maxime Bernier to David Emerson being a liberal and a conservative, we still have these policies that we have right now. And somehow, how do we fix it? And what makes it different now than what's been the path getting us here to this moment?
Thank you, Mr. Massé. And I'll start off on that question. The government's telecommunications policy is guided by three core policy objectives, with competition as the underlying principle. And those are quality, coverage, and price. In particular, our belief is that Canadians should benefit from services that are fast enough to support modern and emerging applications, that are broadly available where they live and where they work, and that are available at reasonable and affordable prices. And while overall, the there's definitely more work to do on the pricing side. It is worth noting that in terms of high-quality networks, Canada's performance remains extraordinarily strong, including above the OECD. And on coverage, 4G coverage is about the same as our European average, and 5G coverage is ahead of that of the EU. Now, on prices, these are higher than our peer countries, and as we've noted, the government has been clear that there's more work to be done.
Okay, there's more work to be done, but I guess what's different this time? So let's go to spectrum right now. How much of the spectrum has been resold in our industry for profit from those that actually bought the original spectrum? How much are we? I think we're up to close to $30 billion that we've actually charged for spectrum, or close to that. How much of that has been resold? So, and we could use even Videotron, for example. How much have they resold of their spectrum, and what type of profit have they made from reselling spectrum, which is a public asset?
I don't have those figures. I could get them, but it's a relatively low amount compared to the amount of spectrum that has been auctioned.
But is it fair to say, though, that we're actually letting people buy our spectrum at an auction, and companies, and then reselling that spectrum for a profit?
So when spectrum is sold as a set-aside spectrum, it comes with conditions whereby the purchaser is encumbered from reselling that spectrum for a number of years. We do that to avoid arbitrage. We do that for a number of reasons. So sale of spectrum would take place in those cases after the provisions had expired.
So would you agree, though, that not using spectrum or keeping it on the shelf for a long period of time affects competition?
Not using spectrum is something that we've tackled. The two most recent auctions and the upcoming one this year have the most stringent deployment conditions we've ever set. So people who've recently bought spectrum and people who are going to be buying spectrum are doing so to deploy it, because if it's not deployed, it will be taken away.
So they're just taken away. Are they actually fined or penalized, or do they have to actually lose some of their economic resource from that? Because if you don't use spectrum, it not only affects the competition, it also affects our Canadian economy related to other businesses that need access to high speed and good service. So what penalties happen to these? My understanding is ISET actually can extend the period of time to not use a spectrum on their own without actually returning to Parliament. Is that not correct? As
a regulator, we work with the regulated industry to bring them into compliance. I mean, that's the number one approach, is the regulated industry to come into compliance. So that's what you start with before, but you start with that before taking it away. We have taken it away, but we like to work with the regulated industry. There could be penalties. Look, if you've paid billions of dollars for spectrum and it's taken away from you, I would argue that's a bit of a penalty.
How much money has the government then, kept from the spectrum, or do you refund the money back to the auction?
We have not taken away recent spectrum that's been auctioned off. People are still within the milestones. When you auction spectrum, you have deployment conditions. The deployment conditions are pretty strict, but they're after the 5, 10, 20-year milestones. Currently, we are not aware of any recent spectrum auctions where the holder of the spectrum is not meeting its deployment conditions.
Okay, but there's been numerous cases of spectrum not being used to its fullest potential. There's no doubt about that. How much money has the government fined then of those people that have won spectrum, those companies that won spectrum? How much have they fined or kept money from that spectrum that's not been used? We know spectrum's not being used.
Sorry, the question is not whether it's being used to its fullest potential, it's whether or not the deployment conditions are being met. And what I'm saying is that the deployment conditions...
And I'm asking how much, when it's not actually been met,
I'm saying they are being met.
Fined? Well, okay, sir, you're saying all spectrum conditions then that we have right now are being met to their fullest capacity.
The recent auctions that we looked at, the 600 auction and the 3,500 auction, the deployment conditions of the people who bought the spectrum are currently being met.
What about the previous ones?
In the previous auctions or in previous spectrum holders, we have taken spectrum away. We have taken licenses away.
When you take it away, how much you've actually fined those organizations and those companies that actually, because it's a public asset. So if you actually,
I understand. I'd have to get back to you. I'd have to get back to you about fines, but we've taken spectrum away.
Merci beaucoup. Thank you very much, Mr. Massé. This is all the time you had, and Mr. Dagenet, feel free to share with the committee through the clerk the information. Je passerai maintenant la parole aux conservateurs. Je pense que c'est Monsieur Williams pour 5 minutes.
Thank you very much, Mr. Chair. Competition helps Canadians by allowing them choice, lower prices, and better service. And there's an alarming precedent being set, I feel, in the divestiture of Freedom Mobile, and that's that Rogers, who's the #1 market share owner of telecommunications in all of Canada, was freely allowed to vet and to choose its #4 competitor, which was Videotron, without the approval of the Competition Bureau. Now, Ms. Pratt and Mr. DeRoche, you've mentioned the merger revenues that is in place in order to approve that. And I'm actually going to talk about paragraph 57, which says, in addition to approving the remedy package, the Bureau must approve the buyer of the divested assets so as to ensure that each asset will be operated by a vigorous competitor and the divestiture itself will not result in substantial lessening or prevention of competition. Did this occur?
So with respect to what we normally do is we'll conduct our investigation. That informs what is the scope of the anti-competitive effects that we need to address. So in this particular case, we went through our exhaustive investigation. We identified the magnitude and scope of those anti-competitive effects. We communicated them to the parties for the purposes of facilitating settlement. We tell them what the problem is, how big the problem is. For resolution, they bring us a solution for evaluation. And the way we evaluate that solution is in accordance with the remedies bulletin that you referenced. When we're doing that, we're looking at, okay, what are the assets? What is the package that the new buyer is going to have to compete with? Is it adequate to allow them to compete on a similar footing to the business that is being sold? So in this particular case, that is where we had concerns with the remedy package.
So just to write it down, did you approve? Did you? Because based on the language in this document, it states that the Bureau must approve the buyer of the vested asset. Did you approve the buyer?
We did not. We did not approve the remedy package, which would include the buyer.
Do you feel that the tribunal properly addressed that concern that you had?
Well, I think our position on this is clear, is that it ought to have been evaluated as a remedy under our framework. And the concerns we had with the remedy proposed included that there weren't sufficient assets being divested with the Freedom business to allow them to compete on a similar footing that Shaw was competing on. So they didn't have the assets. That was a key. There was another concern about the contractual arrangements that were undertaken with Rogers. We generally want to see that a new competitor is going to have the assets and is going to be independent from a competitor with respect to all fundamentals of supply.
Has there been another merger of this size that has not, so to the point of that, you have not approved this. Has there been another merger of this size in Canada that has ignored the remedy process or has ignored your approval?
Well, we are a law enforcement agency, so our job is to investigate, and the commissioner, if he sees a problem and cannot resolve it, has to bring a case before the competition tribunal. That is our framework. That our job is to investigate, see if we can come to a negotiated resolution, which becomes an order of the tribunal under Section 105 of the Competition Act. So that the parties tried to negotiate with us. We couldn't come to an agreement based on the concerns that we had in accordance with our evaluation under our remedies bulletin. We filed an application before the Competition Tribunal. Fundamentally, we disagree with the Competition Tribunal's assessment, but we are a law enforcement agency that has to bring our case before the court.
Are you aware that there were other competitors, other buyers that were trying to buy Freedom Mobile?
We were aware. So at the time, in the lead up to our application, and this is set out in both our notice of application and the injunction materials that we filed before the tribunal. There were a couple of remedy proposals that we evaluated in accordance with our remedies guidance. Those, again, it was the asset package that we had concerns with.
And if you would have had a chance to provide more guidance to their solution, would you have looked at other competitors as an option for a remedy, or do you just look at the one competitor?
We will evaluate what the parties bring to us in terms of a negotiated resolution, but part of that evaluation, if the assets are there, that we think that there's a viable operating business that will address the SLC, we move to looking at the buyer. If the buyer itself raises competition concerns, that is one of the criteria that we apply. So we wouldn't approve a competitor buying if we thought that was also going to lead to anti-competitive effects emanating from the remedy. Those are the things that we look at with respect to the buyer.
Thank you very much. We'll now move to Madame Lapointe for 5 minutes.
Merci, le Président. My questions will be on the Competition Bureau. So you've demonstrated, I think, in a transparent way that both in action and in words that you believe this merger will be bad for consumers. And you've talked about the extensive investigation you undertook that led you to that conclusion. So what I would be interested in hearing from you today is, in that investigation, is what you believe the impact will be on rural communities in Canada. So specifically, this merger, how will it impact rural communities in terms of competition, service choice, and even equitable access to service?
So we didn't look at that in particular because we saw the impact on all consumers generally. So we were concerned about all of those consumers. I can say that before the Competition Tribunal, we did look at the impact on different deciles and income segments, and that was part of our assessment of the anti-competitive effects of the transaction. So we did look at the impact that was going to be on the bottom decile of taxpayers as a result of this merger, and that was evidence that we put before the tribunal.
And what did that evidence indicate?
Well, I think from our perspective, it indicated that there would be a disproportionate impact on lower income Canadians, and we look at the transfer of wealth emanating from this transaction. So it was who is going to suffer, who is going to gain, and that is, we looked at Statistics Canada information, we had experts evaluate that question, and we put that evidence before the tribunal to say that we saw not only there was going to be an impact on consumers, but the wealth transfer would be disproportionate on lower income Canadians.
Now, you also mentioned that as part of your investigation that you heard from over 7,000 witnesses. And can you tell us, were there common themes around what you heard from those witnesses that came to light?
Most of so we received 7,800 submissions from Canadians. I can't tell you, I mean, we looked at each and every one of them, and we evaluate them not so much for the views, but for the facts that they contain, to get the views of Canadians, what the impact of this transaction would be. So our focus is not on their opinion, it's on the impact that this transaction will have on them. So we looked at each and every one of those 7,800 for the facts and the evidence that were in those to inform our investigation.
But can you share with us were there any trends or concerns that you heard from those 7,800 Canadians?
I would have to go back and get the actual, the real numbers of how many were sort of in favor of the merger versus not, but I'm quite comfortable to say that the vast majority of them from consumers were, that they were concerned about the proposed transaction.
So with the final decision of this merger now with the Minister of Innovation, Science and Industry, could you tell us what you think is the most important consideration for those consumers that you've identified would be the most negatively impacted and actually vulnerable to this merger?
So I'll talk about it under our framework. So what we're looking at under the Competition Act is harm to the competitive process. We believe the benefits of the competitive process flow through to consumers in terms of lower prices, greater innovation, greater quality. So our focus isn't on necessarily the consumer. It is about the impact on the competitive process that leads to the benefits for consumers, lower prices, innovation. So, you know, it's a little bit of a different question for us. We're looking at is this particular merger going to enhance the market power of the acquiring firm in a way that could lead to an exercise of market power, an ability to exercise market power that could lead to higher prices, lower quality, and lower innovation across a market.
Merci beaucoup, Madame Lapointe. C'est tout le temps que vous...
Thank you very much. That's all the time you had. Mr. Lemire, 2.5 minutes. Thank you. Ms. Pratt, you mentioned earlier that other offers were around to acquire Rogers. It's been mentioned that
Freedom Mobiles.
such an offer from Global Life that would be boosted by the TELUS network would have had some very strong actions, because that is how you are criticizing the angle with which you are criticizing the sale to Videotron. I don't think that we evaluated such an agreement. This was an evaluation.
The parties bringing, here's an asset package to us. They did a sale process to entertain bidders. They brought us the outcomes of that process, and we evaluated what was negotiated under our remedies bulletin.
Parce que quand on parle de compétition, je veux dire que...
So a player who is supported by the big three is not something that will improve competitiveness, in my opinion. As Mr. Shan mentioned, I agree with him when he says that providers can do better. We have studied some solutions in the committee, and I think that we can objectively redo this exercise in order to see how things can be changed, improved, in order to accelerate the decrease of prices. You have set conditions, for example, a long-term operator who would be committed for 10 years, who could provide wireless services in Ontario and in the rest of Canada. There is a condition. This condition was declared acceptable by Videotron. As such, do you think that a fourth player can indeed provide a service that is durable and reliable? We are now talking about the Shaw Videotron transaction, and I cannot speak to that transaction, as I said earlier. Maybe it's a little bit frustrating, but this is a decision that the minister is dealing with now, and I cannot comment on it. Objectively, do you think that the public policies that you've put in place will welcome a fourth player in a way that can react reliably? I believe that our public policies favor competitiveness with regards to auctions, and also I would maybe ask Mr. Shan to complete the idea. It's important to take note of the improvements of the policies on telecommunications in Canada. In the last year, the government put in place a lot of the new aspects of this program.
Have set aside some of the most stringent build-out conditions in any of our licenses, as well the obligations to ensure that there's significant obligations under the CRTC. We've worked on pricing with the 25% reduction that has been successful to date in lowering prices as per the baseline that we sent out. And the new policy direction for the CRTC completes that in many cases by actually ensuring that we actually look at the overall framework for competition to get at those goals. So we believe that more work needs to be done, but we've laid out the foundations and the pillars, whether it be through spectrum, policy, pricing, or otherwise, including through the new policy direction that can aim to get to those outcomes.
Thank you very much. We'll now turn to Mr. Massé for 2 minutes, 30 seconds.
Thank you, Mr. Chair. So here we are. This is after Bell acquired MTS, TELUS bought Public Mobile, Rogers bought Fido, Shaw bought Win Mobile, and now we're going to have Distribel and Bell on a merger as well. And so I'm not sure if this qualifies the definition of insanity of doing the same things over and over again, but it certainly isn't a pattern of increasing competition. And to Ms. Pratt, one of the reasons I've been concerned for the way that we're doing the spectrum auction is I'll give it a good example. One of the ones is Quebecor, which actually had a carve out and bought spectrum of rural areas for Ontario, Alberta, and BC, later sat on it and finally sold it for a profit of $331 million. My question to you is that with spectrum policies like this and the way that it's actually evolved, is that actually good or bad for consumers and competition? I'm failing to see how we've been rolling the spectrum out improves competition, and I just wonder if you have an opinion on that.
I would say is that we look at each particular transaction under our framework, and we evaluate each particular transaction under that framework. Spectrum is one of the ways that one of the assets that is used in competition in these markets. But ours is a much more holistic examination of market dynamics and the impact of a particular merger and any anti-competitive effects that we think will emanate from that merger. So spectrum is a fact in our investigation. It's not something that I have an opinion on.
Okay, but would it lower or potentially increase competition if we actually do more spectrum, we allow people to sit on it, our companies to sit on it, resell it for higher profits, but then pass those costs on to consumers? Is that, I mean, a model for competition that is seen as advantageous, or would it be potentially better for us to have more stringent spectrum policies so that they're rolled out competition quicker, faster, and also under the basis of what they originally got the spectrum from?
I'll defer to my colleague, Monsieur Durocher. I'm a one-trick pony. I look at particular merger transactions.
More than that.
Yeah. Thank you for the question. Every spectrum acquisition, how it's used, I think the impact on competition would be specific to the facts of that given case. I think more broadly, outside of merger review, the Competition Bureau also has an advocacy mandate where we work with regulators to try and promote regulations and rules to try and enhance competition in the economy. And certainly in the telecom sector, that's an area where we've been very present with the CRTC to try and favor pro-competitive recommendations. And certainly our intention is to continue in that vein.
Okay, and real quickly, do the laws of the Competition Bureau currently satisfy your capabilities to deal with the market and what you have to do for competition in Canada, or do they need to be modernized or reflected of some of our other trading partners? Thank you, Mr. Chair.
Thank you. I think we've been very vocal, and our commissioner has been vocal, that we think it is important to review and thoroughly modernize the Competition Act. And what is very encouraging is that process has started. There have been initial amendments that took effect in June of last year, and the minister has launched a broad consultation to hear from Canadians about how Canada's competition laws can be improved. That is a very important process that was started, and certainly the Competition Bureau is very intent on participating in the process, sharing our views as to where there are specific gaps in the legislation that can be improved. And we are planning to publish our submission in due course with respect to that process, including with respect to our merger review framework.
Merci beaucoup, Monsieur Durocher. Madame Pratt, Monsieur Dagenet.
Ms. Pratt. Thank you all for being here today, Ms. Pratt, Mr. Durocher, Dagenet, and Sean. I will suspend for a moment just to give our other witnesses
Alors, rebonjour.
We begin again. Hello, everyone, again. We are here for the second hour of our meeting. As individuals, Jennifer Quaid, thank you for being with us here in Ottawa. Jennifer Quaid, I will just find the title in French. She is Associate Professor and Vice Dean, Research Civil Law Section, Faculty of Law at the University of Ottawa. Thank you for being with us, Ms. Quaid. We also have Vas Bednar, who's Executive Director, Master of Public Policy and Digital Society Program at McMaster University, who is joining us online. Thank you for being with us. And from the Canadian Anti-Monopoly Project, we have Keldon Bester, who is the co-founder. Thank you for being with us. And finally, from Compass Lexicon, we have Dr. Brian Keating, Executive Vice President. Thank you to all our witnesses for being here today. Without further ado, Ms. Bednar for 5 minutes.
Is it afternoon? Just barely. Good afternoon, esteemed members of the Standing Committee on Industry and Technology, my fellow witnesses, and all members of the public that may be tuning in. You heard that my name is Vas Bednar. I'm the Executive Director of McMaster University's MPP and Digital Society. I'm a fellow with the Public Policy Forum and a senior fellow at CG. I also write the newsletter Regs to Riches. And while I'm neither lawyer nor economist, and I'm happy to defer to colleagues with richer expertise on more technical or legal questions, I am one of the voices that helps to broker a bigger picture in the context of competition for Canadians. And I wonder what I can offer you today regarding the now almost kind of soap operatic Rogers-Shaw merger that you don't already know, right? So for the average person, this process has become more than muddled. We've seen social media chatter conflate the decision of the tribunal with the ambition of the Bureau, but that's not insurmountable. That said, this is the largest merger in Canadian telecom history, and it affects millions of Canadians and the essential services that they receive. One reflection I have that I think is worth sharing is with regards to the thousands, we heard 7,800 of Canadians that took time to make their voice heard in this process, albeit maybe somewhat misdirected at the tribunal. And I wonder if this occurred because there was no formal mode for the public's view to be properly consulted as a complement to policy procedures. You could argue that the minister has a public duty to engage more fulsomely with Canadians regarding this merger and its dynamics and its step-by-step, especially regarding expectations and accountabilities for when it moves forward. This is not quite being done. As a result, the people's appetite to engage on the question has not had an appropriate outlet. So who or what should the people that wrote in that care to follow the ups and downs of this, I said soap operatic, very important, exciting merger look to for accountability? What mechanisms do we have to hold Rogers and Shaw and others to account for the claims that they have made, or to Quebecor to deliver what they have promised or what people expect from a wireless carrier? Even the somewhat gratuitous promises that Videotron has notionally made are unenforceable. We heard that earlier as well. And further, Videotron has made no promises, however weak, on protecting jobs, rural or Indigenous connectivity, or R&D investment. What does that mean for Western Canada? We have this opportunity in Canada where we have an energized and engaged public that's legitimately interested in improving competition outcomes in Canada, understanding our history of corporate consolidation. Fed up, we know that, with what they pay for wireless and internet services. Competition is a topic that's been the subject of countless CBC radio segments, including a marketplace investigation, various opinion editorials from the Globe and Mail's editorial board itself, a Canada Land radio series, and near endless memes. Yes, people care deeply about the outcome of this proposed merger, so if rates later grow, get jacked up, what is their recourse? Perhaps you've received letters asking you the same question. So at this time, I suppose I would encourage all parties to consider complementary policy interventions that can collide with the current consultation on the future of competition policy in Canada. Keep in mind that this is a very technical and abstract question for most people. Even simple interventions can be powerful here, such as labeling flanker brands as they do in the US to help people understand that context of competition. And we need radical incrementalism for competition in Canada and an all-of-government approach, not one narrow window of opportunity in a politically delicate context as a consolation prize. Some have called for more public competition in telecommunications moving forward. Perhaps we also need to look ahead to the benefits of a publicly owned cloud or have a conversation about whether we will have or need a strong Canadian competitor in the low Earth orbit satellite space as Telesat teeters on the verge of bankruptcy. And perhaps matters that intersect with competition in telecommunications should also be considered by the CRTC. Why doesn't it have jurisdiction here except over broadcasting? And day-to-day competition law could be made more open. So finally, of course, this merger is a historic hinge for Canada to take competition more seriously and to be a better broker of these processes. I'm super glad we're talking about it today, even though it sort of feels like a post-mortem. So what's next? Thank you.
Thank you very much. Professor Quaid, the floor is yours.
Merci, Monsieur le Président, honorables membres du comité.
Thank you, honorable members. It is a pleasure for me to be here today. I am Jennifer Quaid. I am Associate Professor and Vice Dean Research Civil Law Section at the Faculty of Law, University of Ottawa. It's not the first time that I have been a witness here. It is a pleasure for me to talk about issues relating to competitiveness and in the current context with what happened in the evaluation of the transaction between Rogers and Shaw. That said, I read the decisions which are right here next to me, and that is what we are used to as lawyers. But I don't hear anybody talking about the content of the decisions unless you do have some specific questions. The decision has been made. I believe that one of the discomforts that exists right now, and I do understand it, is that there's a perception from the public and by others, for example, the Bureau has shared its opinion, by extension, that we don't agree with the assessment. In law, once the tribunal or the court has made the decision, that's that. We can disagree, but they document in a very detailed and clear way why they made the decision that they did. We can disagree, but I am a lot more interested in the future and what we should do now because of the future.
And I will try to make them as briefly as possible. I know I have a reputation for being long-winded, so that's the professor in me. But I'm happy to talk about other things as they will be. The first thing I want to talk about is what the sort of context and what happened in Rogers Shaw should make us think about in terms of the process of review of mergers in Canada, and I'd like to explain that a little bit. Second of all, I think that what happened in this case is a bit of a wake-up call in terms of what kind of decision-making body do we need for competition. There's been long-standing discussion about whether we really have the right model and whether the tribunal, without taking anything away from the devoted and very serious work that the people who've been part of the tribunal have done, I'm taking nothing away from that. I think it's time to reconsider whether we have the right decision-making body. And third, I think there is a serious question, particularly in the context of Rogers Shaw, but it's not exclusively to that, that where we have competition interacting with a regulated sphere, we need to think about some coherence between these two, between these sort of different arms of government. And I think in this case, others who know far more about telecommunications than me, and I am not a telecom expert, I will say that right now, although you're going to hear from one this afternoon, Ben Klaas, there is concern that these two parts of the administration are not talking to each other. It's not working well, and I do think that's something that should concern you. But what does Rogers Shaw, coming to my first point, what does Rogers Shaw mean for merger review? I'm not going to give you a 101 on merger review unless you really want it, but we have to understand that in Canada, we don't approve mergers by and large. We have a process by which mergers are notified to the Bureau through the pre-notification process if they are of a certain size or the parties are of a certain size. There are some transactions that fall below that threshold. But many, many, many transactions are notified to the Bureau. And most of the time, the Bureau will look at it and say, we don't see any problems, you can proceed. But it's not an approval. It's a sort of says we won't object. Sometimes it gets a little sticky, and we have to go a little further along the process. Perhaps the Bureau says, you know what, we need more information. They might issue what's called a supplemental information request, or a SIR. And the idea there is that we need to understand more, and that's often a signal that there are deeper concerns. But all through this process, and I think it's really important to remember this when we start talking about what actually happened with Roger Shaw and the proposal of the remedy later in the game, is that all through this pre-notification process, there's an opportunity to come to a resolution. And that's what happens most of the time. And this resolution is obviously agreed to by both sides. But once again, it's the Bureau saying, okay, we're satisfied that the way things have been changed, or the things you're going to do, or whatever it is that might be, divestitures, undertakings, are good enough that we're not going to object. Ultimately, though, there are a small number of cases, and they really are a small number of cases, that get contested before the tribunal. And it's important to reiterate, because it's said so many times incorrectly in the press, the tribunal does not approve mergers. The tribunal hears an application from the commissioner that says, I have concerns about this merger, and I believe these concerns can be addressed by an order from you, tribunal. So this is a request for an order to resolve serious competition concerns. They have to reach a threshold of, substantial, and that is how this process before the tribunal starts. Without getting into a lot of detail, the significance and I think the importance to keep in mind of why there was such a dust-up over whether we look at the original transaction or we look at the transaction as modified is that proposing a remedy in the context of the contested proceeding has not something that's happened before. And so it is a new question. Now, the tribunal didn't see a problem with it and said, well, look, at the end of the day, doesn't really matter on the burden of proof. We sort of think the evidence is there anyway. But it was an altering of the normal way things are done. And I think for the future, we need to think about whether that's actually what we want to do. I'll tell you what my concerns are, and I'm happy to discuss them in greater detail. The first is that we are now creating an incentive to wait to propose remedies to when things are further along. And that matters from the public interest perspective because the commissioner doesn't invent a Section 92 application overnight. That takes months of preparation. And in this case, factually, there was no deal with Videotron on the table until June. And they did get documents at that time, and then they got the full documents in August. But I think you need to remember that the level of detail, and if you've looked at the tribunal decision, you will know, the level of detail required to prove anti-competitive effect requires serious econometric analysis and lots of information. If you just have the idea that there's a deal out there, that's not enough for the commissioner to prepare a case. They're going to be required to prove things with detailed evidence. You need to know what the numbers are in that remedy. You need to know what the transaction conditions are to assess its impact. And so when it comes late in the game, that is difficult. Now, as a factual matter, and I'll be clear about this, as a factual matter, the tribunal said there was no prejudice in this case. The commissioner was not, didn't suffer any harm. I think that we have to be careful about how much we expect public enforcers to be able to just twist on a dime. But I think that's part of the reason why they didn't go further with it. I will say that the Court of Appeal does allow that it's possible that proposed remedies coming after a challenge is filed could potentially be a source of abuse or could be problematic. But they don't want to explore the conditions of that right now because there wasn't really a live case before them. They didn't think it was going to make any difference in this case. And fair enough, right? But I do think for the future, we shouldn't just be passive about this and say, oh, we'll just leave this Rogers decision like this. What are the conditions under which we would be willing to say we're comfortable that deals can be changed and that maybe this, considering the remedy right into the merger, is acceptable? I have some reservations, and I'll tell you why. It's a feature of our corporate law. It's a feature of our economic system here that companies don't have to consider the public interest. They're not obliged to do that. They're absolutely entitled and free to consider their profit maximization self-interest. In that context, we need to be a little bit careful about saying we're just going to allow unilaterally proposed remedies to just be baked in and we analyze them. So I put it to you. The second thing, my second 2 points, and then I'm going to say them very quickly, is on the tribunal process. And I can't remember if I've said this already, but I think it's a heavy process. It's like a court, and yet it's packaged as an expert entity. I urge you to look at the kinds of expertise that are generally used in the tribunal and whether or not you think that captures the full public interest that might bear on competition matters. For the most part, the expertise is business and economics. The question is, are there other perspectives relevant to the competition questions that come up that we should perhaps ensure are better represented in the tribunal? And honestly, when they talked about accelerating the process and the tribunal had an expedited process, I'm going to give you a metaphor. Imagine an elephant running. Okay? The process of the tribunal is heavy. There are limits to how much you can accelerate what is a court process. Let's examine some other models that are faster. And finally, and this is really a very short point, on regulatory coherence, I really think that as we look at competition reform, we should consider how competition relates to other areas of regulation. And in this case, and I am not an expert, I defer to those who are, it is clear that there is some cross purposes happening here between telecommunication regulation and competition regulation. And I do think that that should concern you. I'm going to stop here and I'd be happy to answer your questions en français, bien sûr, aussi, comme vous voulez. Merci.
Welcome back to the committee. Your perspective is always very interesting. In fact, I forgot the time, and I'll be much less lenient with my colleagues than I've been with you, Professor, because it was so interesting. So we'll now turn to Mr. Bester for 5 minutes.
Thank you so much for the committee for inviting me to speak on this important topic. My name is Kelvin Bester. I'm a co-founder of the Canadian Anti-Monopoly Project, as well as a fellow at the Center for International Governance Innovation. In the past, I've worked as a special advisor at the Competition Bureau and as a fellow at the Open Markets Institute in the United States. I want to be upfront that Global Live Capital, who has an interest in blocking this transaction and who you'll be hearing from later today, is a financial supporter of CAMP, and that we maintain strict editorial independence in our policy positions. So I'd like to start by returning to the conclusions of this committee back in March 2022, conclusions that I feel remain relevant today. This committee correctly determined that the Rogers-Shaw transaction should not proceed, but that if it does, government should use any tools it has to hold the parties accountable to their promises to Canadians. This committee also noted that the laws that made this merger possible, the Competition Act, should be reviewed immediately. As for the situation today and where we might go from here, I would like to stress 3 points. First, while it is entirely possible that Videotron replicates its competitive performance in Quebec and Eastern Ontario, we should set the bar higher than competitive outcomes currently present in Quebec, and that the government should direct the CRTC to monitor whether Videotron makes good on its aspirations to be a disruptive competitor. Second, if we do not use the ongoing review of the Competition Act to reform Canada's weak merger laws, we should expect to find ourselves in the same, if not more extreme situation in the near future as corporations continue to use mergers and acquisitions as a way to reduce competition and entrench their dominance. 2 changes to this effect could be the presumption of illegality of dominant or jointly dominant corporations, the acquisitions thereof, and an explicit preference for outright blocks, as the Commissioner pursued, rather than risky behavioral or structural remedies. Finally, Canada's telecom policy framework cannot remain stagnant as the market undergoes this kind of structural change. The government should act on the proposed policy direction for the CRTC and direct it to review its framework for supporting wireless competition in light of this transaction, including consideration of a full mobile virtual network operator or MVNO model. Because of the approach taken by the merging parties and accepted by the Competition Tribunal, Canadians have limited options to hold the merging parties accountable for maintaining competition in Canada's wireless market. All that remains now is the Minister's approval of the transfer of spectrum assets and the conditions he attaches to that transfer. Following the release of the Tribunal's decision in late December, CAMP wrote that the Minister has the opportunity to strengthen the conditions he laid out in his October statement. These could include more aggressive pricing benchmarks based on international peers, a timeline for reaching those benchmarks, and the consequences for not doing so, which itself could include the introduction of an MVNO model. Entrepreneurs that build successful companies are entitled to the rewards of their hard work, but those rewards should not come at the cost of competitive markets to Canadians. The end point of a system that puts so much emphasis on getting mergers through is the further monopolization of markets that are critical to Canadians, reducing competition when we should be increasing it. One role of effective competition policy is to close off exit options that reinforce the monopoly power of incumbent corporations. Concentration really only leads to more concentration, and an effective competition law, a well-resourced enforcer, and the vigilance of elected officials like yourselves are needed to prevent that slide into monopoly. The committee has done important work studying this issue and raising its profile with the broader public. My hope is that this committee takes what may be its final opportunity to urge the action needed to protect the interests of Canadians. Thank you for your time, and I look forward to your questions.
Thank you very much, Mr. Bester. We'll now turn to Dr. Keating for 5 minutes.
Thank you. Good afternoon. I'd like to thank the chair and the members for inviting me to appear before you today. My name is Brian Keating. I'm an economist at Compass Lexicon, which is the global economic consulting firm. By way of disclosure, I and my colleagues were retained by Rogers throughout the regulatory process. And I think the comments I'll make today were informed by the analysis we did as part of that process. I'd like to discuss the transaction from the perspective of economics. For avoidance of doubt, when I talk about the transaction, I'm really referring to both pieces of the transaction. So the transfer of Shaw's wireline assets to Rogers, and the transfer of Freedom's wireless assets to Videotron. So I'm talking about the transaction that is currently under review, not the original transaction. My colleagues and I have been involved in assessing this transaction in various forms for close to 2 years now. In the course of that review, we looked at thousands of pages of documents, many terabytes of data, and our conclusions about the competitive effect of the transaction are informed by that analysis. And I mean, to me, it's clear that if you are pro-consumer, if you're pro-competition, this transaction, you should be in favor of this transaction. And I'll talk a little bit about why. From an economist perspective, the concern about mergers is you reduce competition, you eliminate a competitor. That's not the case here. There's no situation in which you're going to reduce the number of competitors in any province in either wireline or wireless. The transaction is going to create large benefits through economies of scale and economies of scope. And really, the only parties that are harmed are potential competitors to Rogers and Videotron because they're going to have to compete more aggressively. That's good for consumers. That's good for competition. The conclusion that the merger is good for competition is shared by two independent bodies, as we've heard already today. In December, the Competition Tribunal, after a month of hearings in which they heard from dozens of witnesses and reviewed thousands of pages of documents, reached the conclusion that the transaction would not substantially lessen competition, but would in fact increase competition. And just yesterday, we heard from the Court of Appeals, which affirmed the tribunal's decision, and in fact said from a competition perspective, it was not a close call. I'd like to talk just a little bit about why we reached that conclusion. So on the wireline side, even the competition commissioner did not challenge the transaction. Shaw's and Rogers' wireline footprints do not overlap at all. And in fact, by combining those footprints, Rogers will benefit from the economies of scale that you realize from having a bigger footprint. And we already see the benefits of that competition and the responses from Bell and Telus to the announcement of the transaction and to the process. Both Bell and Telus have announced billions of dollars of investment in their own networks, in part in response to what they anticipate coming out of this merger process. On the wireless side, the combination of Videotron and Freedom, I think it's fair to say, will help achieve a long-standing policy goal in Canada, which is to create a fourth national, or at least national scale, competitor. Videotron's footprint will cover, I think, close to 90% of the Canadian population after this transaction. And like I said, achieving a strong fourth competitor is pro-competitive and will achieve a goal that I think has long been sought in Canada. As with the wireline side of things, there will not be any reduction in the number of competitors in any province. You will continue to have 4 competitors in every province. What the transaction is going to do is it's going to reallocate Shaw's assets, with the wireline piece going to Rogers and the wireless piece going to Videotron. But both are competitors that are well positioned to make use of those assets to enhance competition. I'd like to say a few words about Videotron because I think there's been a lot of talk and a lot of questions about various potential divestiture candidates. From an economic perspective, Videotron is well positioned to compete aggressively. It has strong incentives to compete aggressively. I think the experience in Quebec has been that Videotron's been a vigorous competitor. Prices in Quebec tend to be relatively low relative to the rest of Canada. Videotron also has important assets that it brings to bear. So most importantly, it recently licensed 3.5 gigahertz spectrum. Combining that spectrum with Freedom spectrum makes efficient use of a scarce and valuable resource. We heard questions before about how companies use the spectrum that they've licensed. This transaction is a mechanism for Videotron to quickly deploy its 3.5 spectrum into a 5G network that has the potential to be a really high quality network. It also creates a lot of capacity in Videotron's network. And so if you look at the number of subscribers Videotron will have currently relative to the amount of spectrum and other network assets that it will have a lot of capacity to deliver high quality services, and that creates a huge incentive for Videotron to compete aggressively to grow, to attract new subscribers, and that's a benefit to competition. So we've heard questions about Videotron's commitments and whether they're enforceable. From an economic point of view, our analysis didn't rely at all on those commitments. It really relies on the ability and the incentive of Videotron to compete aggressively. Just maybe two more comments about Videotron. So we heard questions before about Videotron's dependence on various facilitating agreements with Rogers. I think one thing that's important to note, this transaction, by creating a nationwide or close to nationwide network for Videotron, will actually reduce dependence by Videotron on other operators in an important respect. Roaming is a critical aspect of wireless network service. And currently, Videotron, because it's based in Quebec, has to rely on roaming agreements with other carriers to provide service to its customers outside of Quebec. By creating a national, near national network, Videotron actually reduces its dependence on other networks, and that's an important element of competition. And just the last thing I'll say about Videotron is by increasing its scale, it has the potential to realize other benefits in terms of negotiating for handsets, for network equipment, for international roaming. On all these things, I think Videotron has a strong possibility to actually reduce its costs relative to what exists today, and one can expect those costs to be passed on to consumers in the form of various forms of benefits. We've made a written submission to the committee, which involves more detail, but I'm going to stop here and happy to take any questions from the committee.
Thank you very much. And now we'll open up the discussion, starting with MP Viss for 6 minutes. Sorry, Mr. Williams.
Thank you very much. Mr. Chair, Mr. Keating, Dr. Keating, thank you for your comments. On the topic of the divestiture as a whole, and we look at the process of what happened, Rogers itself, the #1 market share owner of wireless in all of Canada, was solely responsible, not Shaw, for vetting and picking its #4 competitor, which is Videotron. So it itself, the company itself, was looking to buy Shaw and was the only entity which was going out to pick its competitor. Do you think that's a fair process?
So I guess I look at the outcome of the process, which is that Videotron is the divestiture buyer. And I think as I just walked through, from my perspective, Videotron is the best situated firm in Canada to acquire Freedom's network assets. So I think it's important to look at the outcome. I understand there are questions about process. I also understand there were, I think, at least 2 other potential divestiture buyers that were proposed at some point. I understand.
So I'm going to ask one now. So Mr. Best, you're representing one of the other ones, I guess. Global Life, for instance, offered almost $1 billion more for the asset, wasn't included in that. So just a question to you, do you believe that the process was fair where Rogers, the #1 market shareholder, picked its competitor, the 4th competitor?
I think the concern with the process, and again, we go back to the outcome, I go to the Bureau being not satisfied. The Bureau prefers to negotiate consent agreements. They do that much more often than go to litigation. So I think if I look at the Bureau's not accepting Videotron as a remedy buyer, I think that's a red flag to me. I think any competitor that is dependent on another competitor for key elements of its expansion plan or its competitive potential is at risk, and that goes for companies beyond Videotron, including what GlobalLive is proposing. So the process.
Sorry, I have so much time. So thank you very much. It makes sense. Professor Quaid, you mentioned that disputing the remedy, this dispute of the remedy from the Bureau is new. So this was a new precedent being set by Rogers not accepting the remedy and moving forward with the deal, and of course what happened to the Bureau. Why is it new, and why is it a big deal that this is a new precedent perhaps being set in this process?
What's new is that it's never come up that you've had a modification, a substantial modification to the deal that's been challenged under Section 92. So it happens that there are modifications to deals, but they tend to happen further upstream in the process. The Rogers-Shaw merger, like many and most mergers, is pre-notifiable. So the Bureau gets notice of what, that the transaction is coming. And that's the moment when you say, oh, and any set of merging parties that know what they're doing, they've looked at their transaction to see whether there are any anti-competitive problems, and they probably have solutions in their back pocket that they're going to come out as soon as the commissioner says, we have some concerns. They're like, yeah, we thought about that. How about we do this? I mean, that's the way it works. But what's unusual here is that it's not until the commissioner has finally filed a Section 92 application that the prospect of a sale to Videotron, which had been in the background, right, for a long time, but that Rogers has said, we're not interested. They tried to sell to private equity first. And it's only after when and I don't know what, I was not in those back corridors. I was not privy to those conversations. I don't know what was said and how much was known, but it's pretty clear from the commissioner's perspective, preparing to challenge a merger that suddenly gets changed that radically is a big difference. And what hadn't been decided by the tribunal before is, okay, can we change the order of the steps that normally happen, which say, first you decide if there's a competitive problem, then you decide if there's a remedy, and that, as is always true in litigation, he who asserts must prove. So if Rogers says this is the right solution, they bear the burden of proving that addresses the entirety of the competitive concerns.
So the question I'd have for you then is, what advice will you have for the minister right now? So the minister does have authority to transfer the licenses from Rogers. What advice would you give to this committee to give to the minister right now?
That's a tough one because the minister's power is discretionary, right? I mean, it's not bounded by the competition process, and in some ways it's a bit of an accident of the fact that telecom is a regulated industry. If this were another merger in another industry, this would be the end. There would be no further step, right? It's just because of the nature of telecommunications regulation in this country. I worry, independent of what I think of the merger and the merits of the merger, I worry about use of political discretion as a way of accomplishing an objective that was sought through a proper judicial process. So I think the fear of political interference is worrisome. I think the minister has to figure out how he can get comfort that these conditions will be met.
And just to your point, you mentioned quite a bit about not having public disclosure. The minister is going to get the public input on this. So therefore, would you not say that the minister perhaps should be looking back at this process, using this as a lesson to look back into probably the flaws that exist in the Competition Act right now, to be able to fix that and to be able to relook at that process?
Oh, there is an ongoing consultation on competition reform, and I would hope that Canadians who have reactions to what happened in Shaw, whatever those are feeding into that consultation, because those are more data points. Yes.
So much. One last question from Ms. Bednar. Are you comfortable with the future of competition in Canada right now with the precedents being set?
I'm comfortable that we have a precedent that we are reviewing our laws and casting a wide net and going beyond the usual suspects and making sure that the future of Canada's competition law is not just shaped by lawyers and economists who can be remunerated for exploiting the weaknesses in the law and continuing to perpetuate Canada's weakness. So I've got to remain optimistic or I can't be a public policy person.
Words of wisdom for us all. Thank you. I'll now turn to MP Dung for 6 minutes.
Thank you very much, Chair. I want to thank all the witnesses for coming. Professor Quaid, it's always good to see you, and I listened very carefully what you had to say, and I have a question for you later. First, I want to ask Mr. Bester, you disclosed the relationship between Canadian Anti-Monopoly Project and Global Life. Are you aware of any sponsoring relationship between Global Life and any of the major telecom company?
Sponsoring relationship? No, I don't believe so.
Any working relationship at all with Rogers, Shaw, Bell, TELUS?
Well, certainly I believe that Global Life's plans for expansion involve a network sharing agreement with TELUS, and I think that is a real question for me. And again, that seems like the kind of dependency that we are similarly worried about with Videotron.
Does that affect your perspective or your position, particularly on this merger?
My perspective is that the Global Live solution is really not a silver bullet to this. I think the merger should not proceed, and we live in sort of a second best world. So in either case, and as I led with, I would like the minister to try to use the tools that he has to encourage whatever outcome he chooses to be the most likely to deliver benefits to Canadians.
Should the minister reject the transferring and which to complete the merger, in your perspective, would TELUS and Bell, their major competitor, benefit from that decision?
It depends. Shaw is a going concern, so I saw them as a serious source of competition out west. So I believe that both, TELUS, Bell, and Rogers, the oligopoly structure, they have an interest in maintaining that structure in whatever form it may come. So I think rejecting the deal would keep, Shaw in play in whatever form it continues to be, which would be a force against, any of the big three that it interacts with.
Speaking of Shaw, my next question is for Ms. Bentner and Dr. Keaton. In your experience, if the government were to reject, or the minister were to reject the merger, what do you think will happen to Shaw? And how does that impact the competition in Canada's telecom sector? Starting with Dr. Keaton.
So look, there's been a rigorous process that we've just gone through, and it's concluded that this transaction, including the divestiture to Videotron, is pro-competitive. So if the minister were to not transfer the spectrum licenses, you would lose the benefits you get from this transaction, and that's a real cost to the Canadian economy and to Canadian consumers. I think with respect to the question of what would Shaw do if this transaction were not to occur, it's probably a question better put to the Shaw witnesses this afternoon. I'm not going to speculate as to what their alternative plans are, but I think you risk losing real benefits that are going to arise from this transaction if it were to be blocked.
Okay. Ms. Bentner.
I mean, it's an interesting thought experiment. I would maybe point to, we've heard about the rigorous competition we're anticipating in this space and the opportunity for innovation. I wonder how innovative telecommunication firms can really have been in Canada over time, when really what they've benefited from is advancements in the products and services that they provide Canadians on the physical infrastructure that they've built, right? Is it innovation if over time you provide a telephone line and then a television cable and then dial-up internet and then wireless internet and then one cell phone to a family home and then everyone has a cell phone? That's a large part of how these companies have been able to grow and reward their shareholders. And what would happen to Shaw? Well, maybe these companies are out of benefits that they can sort of free ride on a little bit and sort of call it innovation.
Back to Dr. Keaton, you talked about the benefits to Videotron and how it, in turn benefit consumers. You talk about the benefit of this deal to Shaw, but isn't Rogers is the biggest beneficiary of this whole merger? Like I noticed that you haven't talked about how Rogers actually benefit from this deal. In my mind, and talking to my constituents, they seem to see that. Rogers is the biggest winner should this merger go forward.
Look, I mean, Rogers wants to do this deal because it expects to benefit from it, of course. Now, I think what's important to remember or keep in mind is that the wireline aspect of this deal is a huge proportion of it, right? I mean, wireline is a large portion of Shaw's business. That's the piece of Shaw's business that Rogers is acquiring. And I think Rogers certainly will benefit from acquiring Shaw's wireline assets, but they're going to benefit along with consumers and along with an increase in
I just
competition.
want to make sure of that because it sounds like everybody else is benefiting from this deal, but obviously Rogers will benefit largely from this deal as well. To Professor Quid, in your experience, should the minister rule to reject the transferring, he will be positioning himself against the ruling of the tribunal. In your experience, has that happened in the past? Was there precedents in the past?
So you're asking something that I don't know directly, in the sense that I'm not a telecom expert. I can't tell you how many times the minister has been called upon to exercise the discretion in awarding a license, spectrum licenses where there was actually a question about, whether he or she would do so. I would say that from the perspective of a lawyer and someone who looks at the law, it is, I think, probably something that you would hope to avoid, that you have a minister that makes a decision on an incident, because the spectrum license is not the entire transaction, right? That you would, make a decision on that as a way of indirectly, achieving something that the properly constituted decision-making body does not conclude. So I would worry about that because it's going to look like political interference or a kind of a workaround. And as I said, this is a curiosity, or if you will, it's a particularity of the fact that we're in telecom and not in another industry where would have been the end of the matter right with the decision of the Court of Appeal. I do think, however, that the minister is entitled to say, I want to look at the full ramifications. I want to understand exactly what's involved, because when he spoke in October, we didn't have a decision of the tribunal. We didn't know how things were going, and he sort of put out some things that he expected. But I suppose within the exercise of his discretion and within, with consulting with the right people and getting the information he needs, he could maybe add to those conditions or insist on mechanisms that allow for accountability. But honestly, the tribunal also recognizes that these conditions are not legally enforceable. And I worry, honestly, that these kinds of undertakings have been done in the past. I think every one of you probably remembers times when there have been undertakings been made in good faith. Oh, we'll keep our head office here. Oh, we'll keep plants open in Canada. And then circumstances change and we renege. So there's a business reason for the change, but it happens nevertheless. And to the extent that the deal rests on that, you have to worry about that.
So we heard from.
I'm sorry, Mr. Dung. We're well over time.
I'm sorry I took too much of your time.
No, that's okay. That's okay. I blame MP Dung, not you, Professor Quaid. Je passerai maintenant la parole à Monsieur Lemire.
On to Mr. Lemire for 6 minutes. Thank you very much. Thank you to each of you for being here today. Mr. Keating, Dr. Keating, after a month, the tribunal made a decision in favor of Shaw Rogers in December. And they said that there were a lot of witnesses, for example, Dr. Mark Kasale. They said that they were open and that he had exposed many of the failings in the witnesses brought forth by the opposition, or the defense, rather. The tribunal concluded that Mr. Israel demonstrated convincingly that the model of the adversary would not have driven prices up considerably, and that the increase that is predicted is actually unlikely. The new agreement between Shaw Rogers and Quebecor was not looked at properly. They only looked at Shaw and Rogers. Can you give us examples of elements that was not presented during the tribunal?
Listening to the translation, I hope I properly understood your question. I think you were asking about the tribunal process and some of the economic analysis that was undertaken. So look, it was a process by there were 40 plus witnesses, including my colleague Dr. Israel, And the Bureau had their own economic expert, Professor Miller from Georgetown. There was a long discussion of the modeling there. I think we had a lot of critiques of Professor Miller's model. One of the most important ones was that he was calibrating his model to data that was almost 2 years old. And really wasn't, because he was using old data, really was not calibrating his model to a proper forward-looking view of what the industry was going to look like. There were many problems with the model that we criticized, and I don't have time to get into all the technical details. I will say that the tribunal, I think, largely, as you said, I think in your question, agreed with our analysis, agreed with the critiques that Dr. Israel put forward about the Bureau's economic expert, and ultimately concluded that his model did not show, was not sufficient to show that there was any substantial lessening of competition because of the transaction.
Do you consider Videotron as being an independent player from the big three, Bell, TELUS, and Rogers?
So, Videotron is clearly an independent player. It is its own company. It operates effectively today in Quebec, and it will operate nationwide, assuming this transaction is cleared. There is no question that they will have various agreements with Rogers as part of their ongoing operations. There's been a lot of discussion about whether that will interfere with their incentives to compete. I think the tribunal process and our analysis showed pretty clearly that Videotron will be able to compete effectively and independently. They will have strong incentives to lower prices, to compete vigorously, just as they have done in Quebec, notwithstanding the fact that they will have certain agreements with Rogers, just like happens in throughout the Canadian telecom industry and frankly throughout telecom industries across the world.
Videotron, if I'm not mistaken, also has agreements with the Bell network to expand its own network, and that's how most companies function in our system. Question for Mr. Bester. You mentioned from the Greco that that you had a specific funder, and you mentioned this as being a conflict of interest. Back to Fox, you mentioned that TELUS wanted to boost the purchasing of Global Life by Freedom. Do you think that this? Do you think that an offer from Global Life that would have been funded by TELUS is part of a strategy to improve the independence and presence of a fourth credible player?
Thank you so much for the question. I think the exact same concerns are present in any sort of deal as you've described. Again, we have a question of, we are now in a world where the replacement competitor, because of the laws that really don't favor mergers being blocked and encouraging competitors to continue to compete organically, we live in a second best world where we're thinking about these different options where, in different cases and to different levels of intensity, competitors are dependent on their own competitors. And so the question of what are the incentives of those big three players in the case of Rogers, in the case of TELUS, that's present in both situations.
They have funded the acquisition or of a smaller player. Doesn't that bring up some dependence?
Related to the telecom provider?
Mon temps se réduit, mais si
I have less time, but if Global Life had bought Freedom Mobile with TELUS's money, then we wouldn't need a fourth independent player on the market.
If that was the case, I would be here saying the exact same thing about Global Live, because it's, again, the big question is, how does that dependence affect the incentive to compete, and why would TELUS and why would Rogers create a truly disruptive competitor for itself? I think that's the big question here.
Merci, Monsieur le Président. Merci beaucoup, Monsieur le Maire. Monsieur Massé pour 6 minutes.
Mr. Massé for 6 minutes.
Mr. Chair, it's normal in part of our democracy to have the Minister of Innovation to actually intervene, not only in this situation, but also in general. We've seen the Investment Canada Act, and we'll have more legislation on that coming up. I look back at the competitive issues and, Zellers being taken over by Target, that didn't help competition. Future Shop being taken over by Best Buy, that didn't help competition. Rona was taken by Lowe's, didn't have increased competition. In fact, the undertakings there were very modest. U.S. Steel gone. Where there has been rejections is a good example is, thank goodness, potash and MDA in terms of satellite. Those have been strong things. And we also have the minister that actually directs the CRTC to some degree by having a mandate letter that also comes from the Prime Minister. And mere fact, we're dealing with the public asset here being the spectrum that we push out there in a system. My first question would be, Mr. Bester, with regards to where we're at now in terms of our policies. I'm just curious as to, is there any other comparative out there in the United States, Australia, or other places that, the U.S. has antitrust legislation different than ours, but what else can we look to fall back on, or do we need to modernize some of our approaches here? And the U.S. is actually looking at some of the antitrust stuff going on now with Google. I mean, historically, this comes as part of their culture. In fact, when you look at, one of the first cases was Standard Oil. So it's part of their actual functioning market economy to have this type of protections for consumers. Could you comment, please?
Question. No, I think the U.S. and Australia in particular are great examples. Australia in the 90s embarked on a really deep policy dive to increase competition and productivity. Part of that was the creation of a really strong central competition regulator, the ACCC, the Competition and Consumer Commission. And I think that's the kind of model we need to be looking at right now. I think competition has been on the back burner. We've had an approach, particularly related to mergers, that is quite lax. And today we look at where we are today, where one of the largest telecom companies can be successful in purchasing a disruptive and upstart competitor. So I think models like the work in the U.S., and particularly Australia, who even after that work in the 90s is now looking to say, do we have the tools, and is likely going to reform their laws. So I think those are two great models to look towards.
Okay, and I'm going to move to Ms. Bednar. You mentioned with regards to innovation in the industry, and one of the things I think the marketplace did a good review of some of the different countries out there, and I'll go back to Australia. And like your comment with regards to, often has been the case is that geography has been used as an excuse for, I guess, high costs and rollout, and like your opinion as to whether or not you think that's valid with regards to the issue. And second to that, there is a condition the minister's asking for a 10-year commitment from Videotron, but I'm thinking like how this industry is going to change over the next year, let alone 10 years from now. And we heard evidence just prior to this panel that there have been no penalties on those that have actually used spectrum to their advantage to actually sell it as an asset and a resource versus deploying it. Could you comment, please?
Sure. I mean, over time, Canada's geography hasn't changed. So I don't disagree with the arguments that help to explain why Canadian telecom infrastructure, the physical infrastructure, has tended towards oligopoly. I don't see that changing in the future, but we have to remember our telecommunications system is one that we built and that continues to evolve. It's not set in stone. We're seeing more experimentation on the services side, right? More independent ISPs. We're seeing more municipalities look to link up their fiber optic network cables. We're seeing the low orbit satellites sort of supplement or complement services or areas where people don't have the best connectivity options. So in terms of what things will look like in 10 years or these promises, I suppose that's why I was also challenging us to think a little bit about where those accountabilities are and what narrative we're going to have. It's certainly one thing to make a very econometric argument to the tribunal. Those arguments haven't been translating well for people in Canada, right? People still feel confounded by this merger going forward, and that's okay. Maybe there's lots that needs to be corrected and brokered, but who or what is best suited to do that? It's not going to be the competition tribunal. And I think that's perhaps a task for this committee to think deeply about going forward.
Thank you. To Ms. Quaid, one of the things that we are really challenged with this business operations that we're dealing with here today is that many other small, medium, and of course large businesses and public institutions, and we've seen this even particularly during the pandemic, are quite tied to the costs and also the servicing. We've had testimony in the past at this hearing that even places like Mississauga, that's in the skilled development of tool and die, mold making, aerospace, and so forth, couldn't get high internet access speeds to their locations just outside the Toronto area GTA. What obligation does the minister, you believe, have to balance this out? I mean, there are a whole series of economic productivity issues at stake here, and we're baking in extra costs, I would argue, as we continue to do these types of mergers. Do you have a kind of an opinion as to what balance the minister has for all the other susceptible costs and businesses have from decisions over competition?
I would ask for a brief answer, please.
I'll take that as a compliment. It's really hard to answer that question, very honestly, in part because as I've declared, I'm not a telecom-specific expert. What I would say, though, is that at a broader policy level, these are questions that have to be looked at holistically. I'm a big advocate of transversal regulation, that the different parts of the regulatory state need to talk to each other, and that economic productivity, but also just the development and the continuing evolution of the Canadian economy has to be done with deliberation and with intention, and not just let things happen to it. And so I guess I'm one of those people who believes there is a place for regulation and for direction. That doesn't mean you create sclerosis for business, but I think something like how to make sure that access is provided, because if you rely simply on the wealth maximizing incentives of private actors, and they are perfectly entitled to organize their affairs in that way, you may not get the outcomes you want from a public policy perspective. So you have to look at how you can leverage those motivations of private business to offer the services you want. And that's not an easy task. I think I'll stop there.
Thank you very much. With the blessing of colleagues, we'll just go for one last short round. Which will put us about 10 minutes over. So I would go with Mr. Viss for 5 minutes.
Thank you, Mr. Chair. Thank you to all the witnesses appearing today and my colleagues. I'm joining you from Mission Matsqui Fraser Canyon, where Shaw has a major presence. My constituents right now are really struggling with the cost of living. And as their representative, and as me coming forward on their behalf today, they're asking me, Brad, will this merger result in a more affordable internet bill and a more affordable cell phone bill? And I'm not necessarily sure it will. And I'm also very highly suspect of Rogers' claim that they are going to invest $6 billion in Western Canada in rural and Indigenous communities that I represent. During the pandemic, I had a mother who lives in Hatzic Valley who's on Shaw, who's still on dial-up internet. And she says, Brad, why won't Shaw just simply cross the road and extend the line to my house? They haven't done so, and they failed to use the spectrum that they've received from auction to the benefit of Canadians that rely on this essential service. So I'm just approaching everything that I say in my remaining 4 minutes or so with that. So Dr. Keating, Shaw Internet customers right now, I'll just say, what prices will be available to the 2 million existing Shaw Internet customers who today get zero talk and text and a $25 25 gig plan? Is Rogers planning on going down to those prices, or should those Shaw customers expect, if this merger goes through, something similar to the Rogers prices, which are, I believe, at $35 and $85 respectively?
So you're going to have Rogers witnesses on a panel this afternoon, I believe, and you should put that question to them. They're better placed to answer specific questions about what plans they're going to offer. What I can say is that from an economic perspective, thinking about the incentives that this merger will create, this transaction will create, our analysis has shown that the transaction will increase competition, which will put downward pressure on prices. The tribunal, and affirmed yesterday by the Court of Appeals, reached the same conclusion. So I think, these questions you get from your constituents are valid and important questions. And I think our analysis shows that, the answer is yes. They are going to get better deals. That's the incentive the transaction creates.
Like on mobile rates, the Competition Bureau's experts found that even with the sale of Freedom to Videotron, prices for Shaw Mobile, Rogers, and Fido would increase in the range of 12 to 14%. The tribunal found, paragraph 246, that even if you adjust these price increases to reflect Rogers' arguments, which I'm assuming you're the one who wrote as their client, as their representative, prices will still go up. So what should my constituents and Canadians across this country be expecting from this merger? Higher internet prices, higher cell phone prices?
So, I mean, as an example, I think it's undisputed that the incentives for Freedom's prices are to go down. I think that the Bureau's own expert, Professor Miller, who I talked about before, his model showed that Freedom's prices would go down. Our analysis found the same thing. So it is true that different plans will have different movements in prices, and I can't speak to the exact magnitudes, but there is a clear incentive for the transaction to put downward pressure on prices because there's really no diminution of competition, and you get clear benefits from reallocating Shaw's assets like I talked about before.
Well, and thank you. And as a representative of Rogers, going back to the $6 billion, what guarantees will be provided to my constituents that those investments will actually be made? Like this is the difference of running a business, of having access to education for my constituents. Why should my constituents trust Rogers and Shaw?
So again, you will have Rogers witnesses on this afternoon. You should talk to them about their specific plans and commitments. All I can say is from an economic point of view, competition will increase as a result of this transaction, and that creates incentives for Rogers to continue to invest in its network, just like Bell and TELUS and Videotron will have.
Thank you. Professor Bednar, with my remaining time, Shaw has a weak record of developing the spectrum that they have acquired in BC and Alberta. Do you feel this merger will improve the development of these essential infrastructure projects that everyone relies upon?
I think that's difficult to speculate on, but what I appreciate about this moment is that we have more kind of eyes on the street here than ever before when it comes to this merger in Canada, and more of a watchdog function, both from everyday people and great interest in the data that's shared through Statistics Canada and from ISED on, costs, how these decisions materially impact people.
Thank
Sorry,
you.
I can't be more helpful.
Thank you. Professor Quaid.
Mr. Viss, I'm sorry, this is all the time you had. We're over the 5 minutes, but thank you. We'll now turn to MP Erskine Smith for 5 minutes.
Thanks, Joel. Professor Quaid, I want to start with you because you've expressed some discomfort with the minister relying upon his discretion under the spectrum license transfer regime to affect an outcome related to competition. But what's your comfort level with allowing the largest merger in Canadian history to proceed under outdated legislation?
Listen, that's a big question to answer, and it's a little bit hard for me because that I didn't listen to all the evidence at the tribunal. I didn't see how the witnesses came across and so on. And whether we like it or not, the tribunal made the assessment of the evidence they did, and they came to the conclusions that they did. So I guess I worry about.
Pause there, because the question that they were answering is whether the deal is likely to substantially lessen competition. I am entirely uninterested in that question. The question I'm interested in answering is this good for competition in Canada? We have a heavily concentrated oligopoly, and rather than moving the pieces around within that oligopoly, it strikes me we should be breaking it up and adding competition at every opportunity we can. And we have an opportunity, and you say it's a political decision, but the political decision is, can we improve competition in telecommunications and reduce prices for Canadians at the same time? And the Competition Tribunal can answer their question related to the Competition Act. The Federal Court of Appeal can uphold that decision. I don't see why we should be bound by anything related to those questions when they're the wrong questions.
That's fair enough, and I think that's the role of the consultation process. And as legislators, you absolutely, and I think that is the right way to look at it, you have the power to look at the state of the rules and to propose changes, and I forcefully encourage you to do so. I believe that there are problems with the merger review provision, but I just worry about using this discretionary decision as a way to work around while we wait to make real changes to the law.
Yeah, whereas I might see it as a way of actually addressing the fact the law is so broken to begin with. But let's talk about the conditions the minister might impose. The minister has laid out 2 conditions. The minister could impose additional conditions. The minister probably should impose additional conditions. But let's look at the 2 conditions that the minister has currently proposed. One is related to the duration of time that Videotron would have to maintain the license for a 10-year period of time. Is that enforceable in any way whatsoever?
It's enforceable to the extent that a 10-year period of time is something that we can watch, right? We can watch the elapsing of time, and we can observe whether or not it's being held. Yes, you can, but
they didn't do the thing we said they should do. Oh no.
Yeah, basically, oh no. I mean, there isn't a way. You can't go to court and say you didn't follow my conditions. I don't know who would enforce that. So it would be reputational.
Yeah, and that's worked in the past. Okay, so related. And this is a question that colleagues of mine have asked, but it's a question I think well directed to you, because in an ordinary situation related to remedy, the Competition Bureau could be heavily involved in the remedy and say, we are going to spin off Freedom Mobile and we are going to have comfort in who the recipient of Freedom Mobile ultimately is. And Mr. Keating's comfortable. He's obviously got, he has a particular client, and he's put a lot of work into suggesting that there's going to be strong competition as a result of this deal in the hands of Videotron. But the Competition Bureau is certainly not comfortable with that. And why should we as Canadians be comfortable if the Competition Bureau is not? And why should we be comfortable with the idea that the first player in an oligopoly, ultimately in this particular instance, is deciding who the 4th player in the oligopoly is going to be?
That's a really hard question to answer, I think, in the sense that you would need to look at, what substantiates the belief. And I mean, the Bureau obviously has the evidence that they think supports that question. I think that one of the things that you may want to ask is, just because there is the capacity to lower prices or the belief that isn't necessarily enough, right? Will those price decreases actually occur? So creating the capacity for competition to happen may not be enough, although the classical belief is that you create the conditions and they should just naturally occur. But I think we observe that sometimes that isn't the case. I think the larger question about concentration in telecommunications is going to require more than just saying we want to change the competition rules, honestly. I think there are characteristics to the telecommunications industry and to the why this industry is concentrated that bear some analysis. But I don't think that it's beyond. Absolutely, this is what your job is as an MP, is to and what legislators should do. We don't like it. We are going to come up with a solution, and it's certainly the case. It's just that's not going to be a legal decision. It's going to be a political decision. But we've made political decisions about mergers before. We said no bank mergers, right?
And from a political perspective, and as I run out of time, I just think it's hard to imagine that Rogers would accept a deal taking much less money if it was going to mean the most competition as against Rogers. It just boggles the mind. Anyway, thanks for the time. I appreciate it.
Thank you, Nate. We'll now turn to Mr. Lemire for 2.5 minutes, pour 2 minutes 30.
Merci, Monsieur le Président. Monsieur Keating, pouvez-vous nous dire...
Thank you. Mr. Keating, can you tell us what kind of business is Global Life, and how seriously do you take their intentions? How did it comport themselves with WIM, and as it was the ancestor of Freedom Mobile?
So I'm actually not an expert in Global Live's business. As I understand it, it is affiliated or run by an individual who's been involved in the telecom business in Canada before. From my perspective, I guess the important thing to think about is that they don't have the assets that Videotron has, right? They don't have, in particular, licenses to 3.5 spectrum. And so if you're thinking about what's the best allocation of resources in the Canadian economy and how best to deploy spectrum that's already licensed, going back to the question that was asked before, the divestiture transaction with Videotron is the best possible combination of network assets that I can see in the Canadian economy, right? You're combining Freedom's network assets and Videotron's network assets. That's something that Global Live, as I understand it, does not have.
Merci, Monsieur Keating.
Thank you. I'd like to talk about the Fox project again. there's certain things that are interesting to point out. There were local campaigns with our MPs, campaigns to solicit the minister, all in order to oppose it. There was the alienation of activists with words like kill the deal or delay the decision. Can there be a revision on the Competition Act? What a coincidence. There were third-party stakeholders, for example, Mr. Cavera posted on Twitter the nomerger.ca initiative to invite citizens to oppose it. Open Media also invites the citizens to send messages to François-Philippe Champagne, the minister, in order to oppose it. What would you say about these kinds of seemingly grassroots initiatives, but that are brought on by major companies? Is this really independent?
Do you want to go first, Vaz, or do you want me to one? Quant à moi, Monsieur Lemire,
here's what I think. This is a problematic issue, indeed. People might have an interest behind citizens' mobilization, and so you would ask yourself, where is the public interest in there? Of course, I hammer on this same issue over and over again, but I do encourage public consultations, and I tell citizens to communicate through this consultation, regardless of what you have to say. And I think it is this government's duty and parliamentarians' duty to hear citizens without, this clean package around it. But we can't separate ourselves from this mobilization because citizens are not necessarily aware of how to mobilize around their discontent. There is real frustration that is being expressed. I'm not saying who's right or wrong, but it is clear that there's a gap between the impact of this transaction and the transaction itself legally and economically. There needs to be more communication if you don't want to have some sort of strong opposition to this project. It is normal also to have a public to have people be skeptical about mergers. But I am not necessarily the person who can take this on. I've done what I can. Collectively, I think we have to inform the public, even if it is a little bit clumsy. Thank you. We will have to go on to Mr. Massé for 2.5 minutes.
Thank you, Mr. Chair. To Mr. Keating, in your analysis, there's been lots of talk about the cost for consumers, but what does your analysis say about the jobs and employment for the various companies that are involved?
Yeah, so I think it's fair to say that neither we nor the Bureau's economists focused on the labor aspect of the transaction. So it's not something that I'm well positioned to comment on. We were focused on the effect on prices and on quality and on consumers.
But wouldn't that actually be important for your estimation in terms of, whether Videotron is going to actually act this time with regards to spectrum and so forth? I mean, we've seen what Elon Musk has done with Twitter without employees. And yet, the most important thing behind all of this is, of course, we have our own pocketbooks and our own costs, but these are real people, real jobs, and it affects the company's capabilities to roll out the promises that are actually projected. And, why wouldn't that information be part of an analysis?
Absolutely agree that thinking about jobs and employment is important, especially to the people most directly affected. I think with respect to thinking about Videotron's incentives and their plans going forward, that's not primarily driven by what's going to happen to employment per se. It's driven by competitive incentives. And I think it's clear from the competitive analysis, both from what we did and also from what the Bureau's experts looked at, that because Videotron's going to have so much capacity and it's going to have a really good network, it's going to have strong incentives to go out and compete. And in principle, that should ultimately be good, I think, for employment. But it's not something we analyze directly.
Okay, well, thank you. Mr. Chair, I just want to conclude by this as saying there hasn't probably been enough conversation about that. And when we talk about the cart and the horse and all those things, and like we're just missing a component here. I mean, how does any of this stuff actually roll out and the promises be made if employment isn't analyzed in this whole endeavor? And there can be no expectations that we could have ever received aside from promises, which I've seen so many years on that. And thank you very much to the witnesses for being here.
Merci, Monsieur Massé. Merci.
Thank you, Mr. Massé, and thank you to everybody who was present today. It's very much appreciated, and thank you for having shared your perspective with us. To all the members of the committee, we'll see each other in 45 minutes for the rest of the session, and it is now adjourned.